Thank you for joining us for Title VI, Providing Language Access for LEP Persons. So as we talk about Title VI, we're talking about non-discrimination. So Title VI of the Civil Rights Act of 1964 prohibits discrimination based on race, color, or national origin in programs or activities that receive federal financial assistance. So we have a quote directly from Title VI written here. And what this means in the way of language access means that you cannot discriminate or limit a person's ability to access public programs based on their ability or inability to speak English. So who is an LEP person? Well, when we're talking about language access and we're talking about non-discrimination, an LEP person is a person who has a limited ability to read, write, speak, or understand English. They don't have to be limited in all of these capacities. They may be able to speak some English, but that doesn't necessarily mean that they have the ability to comprehend written English. Flexibility in addressing these needs should not diminish the utilization of an interpreter, and you must take reasonable steps to ensure that access is provided and that you've got all of these things covered. Now, a person who requires language access or language assistance through your program, it may not necessarily be the patient or the primary person, your client, the primary person that you're dealing with. It could be that you're needing to provide an interpreter for the caregiver of this person. They also qualify. In the case of maybe a person who has limited mental capacity or a child. So when we're talking about non-discrimination and we're talking about limited English proficient individuals, we're talking about their right to language access. What are the language rights? Okay. A person who has the limited ability to read, write, and speak or understand English, they have the right still to use public programs just as anyone else would and communicate in their preferred language. They should set a language preference with you so that they can receive written vital materials. And they have the right to an interpreter at no charge, but someone who is qualified and trained in the subject matter, also someone who is impartial and ensures that everyone understands what is being said. So when it comes to language rights, what is your program actually obligated to do? Well, here's what you have to do. If you're a program that accepts federal funding, like Medicaid, Medicare, federal grants, anything of that nature, you're required to provide language assistance at no cost. That would include a trained interpreter at no cost to your client, so someone who is adequately trained in the subject matter that you're dealing with, and at no cost to your client. It also means that you provide the client with documents written in their preferred language that are vital to the program. So what exactly does a vital document look like? What does that mean? Basically, this is any, depending on the frequency of the language, important written information must be translated. This may include an application to participate, a complaint or an intake form, notices of rights or notices to be able to appear, assessments that are used to determine eligibility of services, school documents, standard forms that are considered vital, such as maybe a disclosure, content on a website. If this is something vital that you need to give to every person, then you need to have it translated so that you can provide it to your LEP client as well. So when we talk about vital documents and LEP clients and finding interpreters, it can all seem rather big, kind of like a tall order. But having a language access plan will help you to ensure that nothing falls through the cracks. Your plan doesn't have to be complicated. You need a process for identifying individuals who are going to need language assistance. You need to know how those individuals interact with your program or your agency. Everyone who interacts with the LEP community in your agency needs to know what your language access plan is, and how to access services if they need them. You need to determine which documents are important and need to be translated. You also need everyone to be trained on how to find those documents. Make sure that you create a notice that is visible to everyone who comes into your office or on your website, that language access is available free of charge. And you should designate a person in your office to monitor and update your plan periodically. So who is an appropriate interpreter? What makes a qualified interpreter? Well, first of all, an appropriate interpreter is someone who is a professional, someone who is trained in subject matter, someone who is qualified and has been through qualification processes, and someone who is impartial. Good examples of someone who is not an appropriate interpreter would be a child, someone who doesn't understand the terminology, someone who is unqualified to translate. So just because a person is bilingual does not make them qualified. And a person who is partial, like a family member or a close friend. Now, Catholic Charities actually has another training video regarding working with interpreters and what an interpreter can and cannot do. But just as a short summary, an interpreter should treat you with respect. They're going to make sure that your client understands everything that you say. They're going to make sure that you understand everything that your client says. And they're going to keep all of these conversations completely confidential. Things that an interpreter is not going to do is change your words or leave out information. They're not going to talk about you, they're not going to take sides, and they're not going to give their opinion about what you should do. And just so that you know, when we talk about leaving out information, if there's something that you don't want to say to your client, please don't say it in front of your interpreter, because they are required to relay everything. So in conclusion, Title VI requires recipients, and by recipients I mean you. If your agency accepts federal funding, you are a recipient. So it is up on you to provide meaningful access, language access to LEP individuals. Recipients need to have a written LEP plan, and make sure that all of your staff knows where it is and how to use it. Federal agencies can investigate complaints for non-compliance of Title VI. So if you are required to comply with Title VI and you're not doing it, you should probably start working on a language access plan, and we can help you with that. But it is something that the feds can follow up on. And any person in Kentucky who needs to make a complaint about noncompliance can do so with Region 6 of the U.S. Department of Health and Human Services. So Catholic Charities has provided translation and interpretation services for nearly 30 years to the Louisville area. We specialize in interpreter training and providing language access plans. For more information, you can contact us at 502-509-8521 or send an email to us at languages@archlou.org.